You are Mr. Rosabal Matos.
Sí.
Yes.
Sir, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Judge, on April 19th, 2025, in Harris County, Texas, an officer observed the defendant run a red light on North Shepherd Drive. The officer then observed the defendant's vehicle fail to drive in the designated lane, striking the raised median and causing his tire to go flat.
This right here textbook probable cause. One red light, one tire on the median, and a 153 breath test. That's all the judge needs to elevate this from just another DWI to a Class A misdemeanor. But here's a question. Should one mistake behind the wheel really risk a year in jail? Let's see how the judge plays this one.
A traffic stop was conducted. The officer made contact with the defendant and observed the defendant to be the driver and sole occupant and to have bloodshot eyes and slurred speech. The officer could smell an odor of alcoholic beverage emitting from the defendant's vehicle and from his person upon his exit from the vehicle. Officer Castrejon spoke to the defendant due to the defendant being a Spanish-only speaker. The defendant admitted to consuming one beer. Standard field sobriety tests were conducted. The officer noted a 2 out of 6 on the HGN, but also noted that the defendant would not follow the stimulus during distinct and sustained nystagmus at maximum deviation. Therefore, the officer was not able to observe the clues on that basis. The officer noted a 3 out of 8 on the walk and turn and a 3 out of 4 on the one-leg stand. The DIC was read on a recording in Spanish at the Joint Processing Center. The defendant consented to a breath test. The 15-minute waiting period was observed and the breath test came out to a .161 and a .153.
Any prior DWIs and a license?
No prior DWIs, Judge. I'm checking on the license.
Que si tengo licencia.
Find
Sí
that there's
tengo.
sufficient probable cause.
Voy a averiguar que sí es
Case.
obligatorio. Sí,
I'm
consta
ordering
su-
you as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're consuming, I will revoke your bond and put you in jail. If you're not in this country with proper permission and you go to jail and immigration finds you, they will put a detainer on you and you will be stuck in custody until this case is over with and they get shipped off to immigration. They sleep it daily, hourly. So behave while you're in this country. You get no more warnings from us. Do you understand?
Okay.
If you do not have a Texas driver license and liability insurance, you're also ordered not to drive.
Sí tengo.
I do have.
Judge, it appears that it is eligible.
Parece que sí.
As
Sí,
long
tengo
as you have a
Texas.
valid license
Sí, sí, sí,
and
tiene.
liability insurance, car insurance, then you will be able to drive. That is also a condition, that you maintain liability insurance.
Es que no tener aseguranza de-
Do you have the ability to hire a lawyer?
¿Tiene la capacidad de ocupar su propio abogado?
No.
No.
I can have you fill out an application, but I need to know everything about you. I need to know what kind of work you do, how much money you make, how much money you have at the bank, what kind of car you drive, any other sources of income, and I'll take a look to see whether you qualify. For now, Deputy Miranda's going to give an application. I'm going to have you go to Victoria, sign a reset, and then we'll have you take a seat in the jury box while we take a look at everything. Please.
Just real quick on 13, top of 13, was that state fund conditions?
Yes.
Oh,
Yeah.
There's another stuff. Easy. Next judge is page 23, Vera. 25605. Okay, 25605. 0573.
I know, I'm getting sent. Don't be calling me on Monday because I'm big for a margarita.
You are Mr. Vera Quiroz.
Yes, sir.
Sir, you're charged with
No.
driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On April 17th, 2025, an officer responded to a call for service for a possible failure to stop and give information in Harris County, Texas. The witness stated to the officer that he observed the defendant strike a maroon four-door sedan from behind, drive around the vehicle, and then drive away from the scene without stopping to provide any information. The witness followed the defendant and observed the defendant to increase and decrease his speed frequently, fail to drive in a single lane of traffic, and nearly strike other vehicles until his car became disabled on Highway 249. The witness observed the defendant to exit the vehicle and to be the sole occupant and operator of the vehicle. The officer made contact with the defendant and observed a strong odor of alcoholic beverage, glossy bloodshot eyes, and poor balance. The officer detained the defendant, and while removing a pocket knife from the defendant's pocket, the officer observed a bulge and a plastic feeling in the defendant's pocket. The officer observed a faint odor of marijuana, so he removed the plastic bag, which did in fact contain a usable amount of marijuana. Standard field sobriety tests were conducted. A 6 out of 6 was reported on the HGN, a 5 out of 8 on the walk and turn, a 1 out of 4 on the one-leg stand. The DIC audio was played for the defendant, and the defendant agreed to a breath test, which yielded a .148 and a .143. The marijuana weighed approximately 0.2 ounces.
Priors, no license. Mr.
No,
Vera,
no priors, Judge.
No.
okay.
And
No driver's license.
No, tengo
Mr. Vera, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now, as a condition of your bond, not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. With you, I'm going to test you 50 days from today. If I find that you continue to use marijuana, I will revoke your bond. I'm going to put you in jail. If you're not in this country with proper documentation and you go to jail and immigration finds you, they will put a detainer on you because they sweep it daily.
That line, in this short life that we have, do not drive. You can hear the exhaustion in the judge's voice. After dozens of repeat offenders, he's pleading more like a parent than a prosecutor. This is where justice meets frustration, and the human side of the bench really shows.
Do you understand?
Yeah.
Yes.
You are not allowed to drive if you don't have a Texas driver license and liability insurance. That is also a condition of your bond. You do not have a license, you will be signing an affidavit with me today. Mr. Vera, in this short life that we have, do not drive, because if you do, you will pay dearly. Do you understand? This is a promise that you're going to make to me, that you're documenting that you're not going to drive. Nothing you say can justify driving at all. Do you understand?
Yes, sir.
If you get a license and insurance, come talk to me, and then I'm happily will take this off. But until that point, you do. Do you have the ability to hire a lawyer? How old are you, Mr. Barrett?
Yes.
No.
23?
Do you work?
Yes.
Do you have the ability, do you have the funds to hire a lawyer?
No.
If you want, I can give you an application and you can apply for a court-appointed lawyer. I need to know everything about you and I'll see whether you qualify. Above all else, do not use because it's really not going to go well for you. Do you understand? Okay. Deputy Miranda's going to give you an application. I will have you go to Victoria, sign a reset. You're eventually going to meet with pretrial services for your bond conditions. After that, we'll take a look at your application. Come on.
Judge, we have one more. Plaza.
Hey, Glossa, you're earning, huh?
My vacation, right?
You're doing great.
The bottom of page 8, Judge. I don't know how to say that much.
You are Arthur Mukes. Mr. Mukes, you're charged with resisting arrest, facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Please.
Thank you, Your Honor. A law enforcement officer was dispatched to a disturbance call on April 19th, 2025 in Harris County, Texas. The officer observed the defendant to be outside of the residence with what appeared to be an injured hand. The defendant stated he injured his hand while punching a wall when he was in an argument with his wife. The defendant stated that he had been drinking Crown and requested medical attention to the scene. The officer attempted to make contact with the female at the residence who refused to open the door. She only stated that the defendant should not be there at the residence and that she was in fear of the defendant. The defendant advised that he would leave the location and return at a later time. Later on that day, the defendant contacted Precinct 7 dispatch and stated that he was going to kick the door down at the aforementioned residence. The officers returned to the location and made contact with the defendant, who stated that he was going to kick the door down as soon as the officers left the location. Due to the defendant's apparent intoxication and the danger he posed to himself and others, the officers attempted to place the defendant in custody for public intoxication. The defendant became actively resistant and pulled away from officers while being escorted to the vehicle. The defendant told the officer, quote, "I'm coming for you," multiple times as he refused transport. The assistance of 4 officers was required to place the defendant in a patrol vehicle. The officer notes that the defendant actively resisted for 7 minutes and 13 seconds.
Mr. Mukes, I'm going to find that there's probable cause to go forward. Now's not the time. I know you're itching to say something, but look, I've got a bunch of prosecutors here. I don't want you to say something that hurts your case. Stop. Resist all attempts. If you want, I can give you a lawyer today and you can give your side to the lawyer. Okay. But right now, don't. You're only hurting yourself more when you think you're helping. Don't. I'm trying to help you here, Mr. Mukes. The only condition I'm placing on you now, you're not allowed to consume alcohol. Do you understand? If I find that you're using alcohol or illegal drugs, I will put you in jail. Just don't use. Okay? Do we know if she wants to have contact with him?
Judge, the offense date was on the 19th. We have not been able to reach out with the complaining witness yet.
So let's do this. I'm going to have them reach out. I want to know if she wants to have contact with you. If she's okay with it, then I'm going to allow it. Okay? Just don't. So we're going to try to do work on our side or their side to see if they can reach out to her and see if she's okay with contact with you. So let me see.
Morales Vega?
Okay. So, hey, do you mind reaching out to the MAC for Mr. Mukes? I'm going to get you a lawyer here pretty soon. I'm going to have you sign a reset with Victoria. We're going to have you take a seat in the jury box. Just look. Just don't. All I'm asking you to do, man. Okay?
I was the victim here and hell.
I know there are two sides. Mr. Mukes,
I'm the one who called them for help and they locked me up and violated my rights.
hey, Mr. Mukes, there will be video. We will take a look and we'll see because the evidence is going to point to whose side's correct. I don't know. I wasn't there. Stop. Don't. Please. Good morning, Mr. Ramirez. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On April 17th, 2025, in Harris County, Texas, an officer observed a pickup truck change lanes without using a turn signal. The officer observed the vehicle change lanes twice prior to initiating the traffic stop. The officer approached and observed the defendant to be the driver and sole occupant of the vehicle. The officer noted a strong odor of alcoholic beverage emitting from the defendant. The defendant was ID'd by his Texas driver's license. The defendant stated that he did not know how to provide proof of financial responsibility. As the defendant responded to the officer's questions, the officer noted an odor of alcoholic beverage emitting from the defendant's breath. Standard field sobriety tests were conducted. A 6 out of 6 was reported on the HGN, and the defendant stated that he could not perform the walk-in turn or the one-legged stand. The DIC was read, and the defendant refused to provide breath or blood voluntarily. A blood warrant was obtained and the defendant's blood was drawn.
Yeah, may I respond?
Please.
Okay, first of all, Judge, the reason, it's not on there for some reason, but the reason he told the officer he can't do it because he had surgery to his back and to his knee, he can't do it. Secondly, there's no mention of any slurred speech, no bloodshot eyes, no swaying.
I mean, I was actually thinking about that as well. All you have is an odor of alcohol.
And
Anything, there's no accident. It's just a turn. All we have is an odor of alcohol. Is there anything else? Odor alone is insufficient.
No, Judge, he was coming from a tattoo shop and the police officer asked him,
And there it is, no probable cause. The judge basically says, smelling like alcohol isn't a crime. You can feel his sarcasm when he drops that "You're killing me, Smalls" line. Classic courtroom burnout meets comic relief. What do you think, fair call? Or did he just let one slip through?
the alcohol because of the tattoo.
Is he what?
He just had a tattoo put on. That's the odor of alcohol.
Come on, man.
I'm just saying. I mean, that the officer actually asked him that question.
What are they, the little alcohol that you put on your skin, you tell me that?
I don't know how it works, Judge, but I've never had a tattoo.
You're killing me, Smalls.
Your Honor, the law enforcement officer does state in the DIMS that there is a distinct odor of an alcoholic beverage emanating from the defendant's breath as he spoke.
Yeah.
That's
That it?
all we have before we initiated the standardized post-firing test.
Okay, that's not enough. All right, I'm gonna find no probable cause in your case, Mr. Mears.
So
We have enough death on our streets now, $40. One button will get you a car wherever you want to go in this life. You know what I mean?
Yes, sir.
Use it. All right, please.
Thank you.
Thanks, Frank. You are Mark Ramirez. Mr. Ramirez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
Thank you, Your Honor. On April 18th, 2025, in Harris County, Texas, an officer observed a motor vehicle stopped in the right lane of traffic with its hazards on. The officer approached the motor vehicle and observed the defendant to be asleep in the driver's seat. The officer parked his motor vehicle in front of the defendant's vehicle and attempted to wake the defendant up. Once the defendant was awoken, he allowed his motor vehicle to roll forward and strike the officer's vehicle. The defendant then turned the vehicle off, but failed to put it in park, leading the motor vehicle to roll backwards and strike the other officer's motor vehicle that was on scene behind the defendant's motor vehicle. Once the defendant exited the vehicle, he became uncooperative and was required to be detained by the officers. The defendant would not answer any questions and kept saying, "Oh yeah," over and over. The officer observed a strong odor of alcoholic beverage emitting from the defendant. The defendant declined to participate in standard field sobriety tests initially. Once the defendant was transferred to jail, the defendant stated that he wanted to perform the standard field sobriety tests when asked to perform them again. The defendant was read Miranda warnings and stated that he wanted to speak to the officer. The defendant then stated that he had a 12-pack of beer since he had gotten off of work. The defendant stated he did not know what time it was and what time he stopped drinking. The officer observed the defendant to have bloodshot eyes and slightly slurred speech. Standard field sobriety tests were conducted. A 6 out of 6 on the HGN, a 3 out of 8 on the walk and turn, a 2 out of 4 on the one-leg stand. The DIC was read, and the defendant consented to providing a blood sample.
Ramirez, I'm going to find that there's sufficient probable cause to go forward with the case. If you have a problem with drugs or alcohol, now is the opportunity that you're going to get to address it. If you don't, and it becomes a problem on bond, I'm going to address it for you, and I promise you're not to like the way that I do it. Do you understand?
Yes, sir.
You are not to use alcohol, illegal drugs, unprescribed controlled medication. I'm going to test you like crazy to ensure that you're not using. Any prior DWIs, and does he have a license, please?
Judge, I don't have any prior DWIs, and I'm checking the license right this second.
If you do not have liability insurance and a Texas driver license, you're not allowed to drive, and that is also a condition of your bond.
Judge, we have that his license is eligible.
Okay. Do you have the ability to hire a lawyer, Mr. Ramirez? Do you work? How old are you, sir? Okay. We're going to give you time to hire a lawyer, so I will have you go to Victoria, sign a reset, and then I'm going to have you take your seat in the jury box while we get your bond conditions. A, don't use. Do you understand? You're going to get called to tested. If you fail to appear, I'm going to issue a warrant for your arrest. You understand? All right.
Hello, sir.
Ma'am, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Thank you, Your Honor. On April 17, 2025, in Harris County, Texas, officers were dispatched to an assault call. Officers arrived and spoke with the complaining witness, who stated her and the defendant are neighbors. The complaining witness stated the altercation was only verbal until the complaining witness exited her apartment unit and observed the defendant approach her while calling her names. The complaining witness states that the defendant then struck her 3 times on the head with a closed fist. The complaining witness stated a witness was able to separate them. The complaining witness exited her apartment unit approximately 1 hour later, at which point the defendant approached her again while stating that when the defendant was in jail, she heard the CW was talking bad about her. The complaining witness stated that the defendant then struck her on the face and head with a closed fist 5 to 6 more times. The witness stated he observed the defendant pulling the complaining witness's hair, but did not witness any striking or punches thrown. The officer observed a light red mark on the complaining witness's cheek.
Any alcohol?
Take a closer look here.
Ms. Simmons, I'm going to find if there's sufficient probable cause to go forward with the case. I'm going to tell you now that I will do everything in my power to protect my community at all costs. I don't know what kind of resources you have here, but if you don't have anyone to pony up $5,000 to $10,000 if I revoke your bond, you will be stuck like Chuck in there until this case is over. Do you understand?
Yes, sir.
I don't want you to consume alcohol or illegal drugs, and I don't want you to have contact with the complaining witness in this case. I don't want you to go within 500 feet of where she lives or where she works. You understand?
We live right across the hall from each other.
Don't want you to go anywhere near her. I don't want her to be in fear of when she's trying to get home.
I understand.
Actions have consequences, and I don't want you to go anywhere near where she lives or where she works. You're also not in possession of weapons as well.
Judge, after taking a closer look, it doesn't specify whether or not alcohol played a role in this event.
Do you have the ability to hire a lawyer, ma'am?
No, I don't, I need one.
Okay, I'll give you an application. We'll see whether you qualify. I need to know everything about you, how much money you have coming in, where from, cars, anything, money in the bank, and then we'll take a look to see whether you qualify.
All right, thank you.
Miranda's going to give an application. You will meet with Pritchard for your bond conditions, then we'll have you meet with someone shortly.
Okay.